save my voice for the important stuff.
We're not going to call on anybody. So,
so you guys are okay.
Take the $100 bill under one of the chairs.
So we did have a handout. Did everybody grab that as they came in? Here, I can. We're not going to go over it in any detail tonight, but we're just for your information, perusal later.
Okay, yes, that's fine. There's not a whole lot of room up here. I think we'll wait just a couple more minutes, make sure we get everybody.
Say go ahead and get started.
Okay, sounds good. Hi, I'm Abby Lindgren.
I'm Cady Troester.
And I'm Jordan Hohwieler.
And we are law students at UNL, and we are senior certified, so that means we can act as attorneys under the supervision of a licensed attorney, Brett Stowes. Can everybody hear?
Is everybody at the distance campuses able to hear us? I don't.
Can you give us a wave?
Yeah? Good? Okay.
Great. So all three of us are currently participating in the Entrepreneurship Clinic, which just means we are essentially first chairs. So we interact with clients, we email, we have client meetings, we draft anything that needs to be drafted, we help form entities for clients, and a bunch of other different range of topics that we do for the clients. So tonight we're here to talk about business succession planning and how valuable it can be to the sole entrepreneur and if you have a business partner as well. So kind of things we'll be talking about today. So first, Jordan will be addressing how to determine your business succession goals. So priority number one, figure out where you're going, and then we'll talk about how you can get there. And then Jordan will also be addressing entity formation and its benefits and how it can play a part in your business succession planning. And then Cady's going to be addressing personal estate planning and how that can play a part in business succession planning. And then I will be talking about accessing digital accounts and information in the event of incapacity and death. And then we will finish off with some business succession tips. So, Jordan? Yep.
All right, so starting off with just a basic definition of business succession planning. It's the strategy of passing on both ownership and management of your business or your company to an individual once you're no longer there. And it's good to break it out into two different parts. There's your long-term goals, which is what you want the business to do after you retire. But then also you need to think about emergency situations. So if you were to pass away tomorrow or become incapacitated, you also need a plan for how the business could be operated in a worst case scenario situation like that as well. So to kind of demonstrate some of these ideas we're going to talk about tonight, we're going to use Joe as an example. So Joe has a sandwich shop here in town as a sole proprietor, and it's a new business. He took on a lot of debt to get it up and running, and on the way to work one day he gets hit by a bus and dies. And before this, he didn't form an entity, did zero estate planning. So what are the consequences of this? A number of bad ones probably. You can imagine if Joe has a family, they would be responsible for paying the debts of the business because he didn't form an entity. Also, Joe's employees aren't going to know how to carry on business without their fearless leader. And then third, if Joe had accounts password protected, and he didn't share that information with anybody, and didn't have a plan for this type of situation, the employees of the business aren't going to know what outstanding orders there are. So there's three basic ways to transfer your business. There's family, non-family, and then allowing the business to dissolve. So that would not really transfer to anyone. It just ceases to exist after you pass away. So the first one is transfers within the family. So when would this make sense? If you have adult children or a spouse that's experienced that they know everything about the business, they could step in and be a seamless transition. That's the ideal. As a business owner, it gives you the peace of mind that the business that you've been working in, that you built from the ground up, you're not giving it to some stranger. The assets aren't just being sold. And it can allow you to pass on the business to future generations. There's a number of drawbacks. Making business decisions within the family can be messy, right? We see this with estate planning a lot too, but sometimes it's necessary to have those difficult conversations up front rather than your family dealing with it on the back end. And another downside you could imagine is the successor family member might not be prepared right away to step in. So if your plan is to leave your business with your children and they're in high school, obviously that's not going to work out. So you're going to need to work out some contingencies. Okay, the second option is just non-family transfers. So this would make sense if you're operating with a co-owner or you have a trusted manager operating the business. The benefits of passing to non-family members are both you're ensuring the departing business owner is going to get your value out of the company, but then also the other co-owners can retain control of the business, and they're not going to be forced into doing business with strangers that might otherwise happen. So the drawback here is the successor business partners might not be able to fill the shoes of the owner that they're stepping into. We could imagine that happening. So the third situation, if you don't have family to pass it on to, you don't have a co-owner or a manager, a trusted employee, a third main option is just to have the business cease to exist and dissolve. So when I say dissolve, it means basically all the assets are sold, and then the Secretary of State files a document that basically says the business ceases to exist. So this can be planned if you don't have family, you don't have co-owners, or this can be unplanned where you don't take any of the steps we're going to recommend tonight. This would be the default option for many sole proprietors. The benefit of this would be a liquidation event. So if you need to cash out of your business and you don't have successors lined up that make sense at this time, that would allow you to liquidate your assets. Disadvantages, you can imagine it's a huge burden on your family, not planning and them having to sell the assets of the business, having to do all of this after you're gone or incapacitated. So that would be the downsides. So after that planning stage, you should know who you want to take over your business, both in the short term and then long term when you retire. And one of the most basic ways you can plan for this is to form an entity. There's 4 main types of entities that I'll talk about. The sole proprietorship, which isn't really an entity, but we count it anyways. The partnership, corporations, and then the LLC. So starting off with the sole proprietorship, this is just anyone operating a business on their own, and they haven't taken any steps to form a corporation, LLC, anything like that. So they're treated just like an individual. Even though they're carrying on a business, the law treats them like all of the assets of their business are personal assets. So for liability purposes, all of the business Debts are the personal debts. So that's the big downside. If you remember Joe, he passed away, he didn't form an entity. Because of that, any debts that existed at his death, his family would be responsible for paying. So that's why if you're operating a business with a large amount of debt, that's all right. Okay. We don't recommend operating as a sole proprietorship, especially if you have debt, but generally not in any case. Okay, the second type of entity is a partnership. So unlike the sole proprietor, it's actually a separate legal entity under the law. And it's kind of unique in that you don't have to file any documents or create a contract with your business partners. As long as you are engaged in business with a partner or two or more people, and your goal is to make money and share the profits, under the law, you're treated as a partnership. So that would be kind of the accidental way to stumble into a partnership. Most often, it is intentional, and a partnership agreement between the partners is formed, and that document, the partnership agreement, controls how assets can be passed on, both in business succession planning or just the day-to-day business, how decisions are made. So that would be the partnership agreement. For liability, all of the business debts, that liability stays within the partnership, right? So let's say there's two partners and they get sued. Only the assets within the partnership would be at stake for paying off that liability. So it gives you a little more protection than the sole proprietorship. The third type of entity is a corporation, the C Corp, I guess. So unlike the first two I talked about, C Corp, you actually have to file documents with the Secretary of State. So it would be one filing, which would be the Articles of Incorporation, thanks. So that would be simple document, you form a corporation, and this is generally looked at as the best way to shield yourself from liabilities, right? So only what you put into the corporation is subject to loss. So that's the upside of it. The downside is it's seen as kind of burdensome for small business owners because there's so many formalities. So there has to be a certain amount of officers, directors, they have to have meetings per year, other administrative complexities that people don't like to deal with. So the fourth entity kind of gives you the benefits of limited liability, as well as less of that administrative burden. So that's why it's kind of more popular, and it's I don't want to say go-to entity for small business owners, but it's pretty easy and allows the flexibility, and it gives you the limited liability, the main feature. So like the corporation, you actually do have to file documents with the Secretary of State to form it, and then the operating agreement is the document that basically controls how the business is run, and it can be useful in determining your business succession plan. So you can designate who you want to take over for you in case of emergency, or Abby's going to talk about buy-sell agreements, which are executed in conjunction with forming an LLC. So at this point, I think I'm passing it off.
Thank you. And just a quick point of clarification here. I'm going to back up quickly to partnerships. What happens with your personal liability in a partnership is actually that it stays your personal liability. Just like with the sole proprietorship, there's no liability protection in a partnership like you get with a corporation or an LLC. So just a point of clarification there. It's kind of what makes it a little scary in conjunction with this accidental formation idea that's out there. So let's resurrect Joe. And we're going to put him back in time and he's listened to our presentation and talked to his attorney, and he's decided that he's going to form an entity. So he's got an entity, he's got some business partners, and his sandwiches are flying off the shelves. So because of that entity, he's got his limited liability. His family is protected from having to pay any debts that might be outstanding as long as he didn't personally guarantee them. But unfortunately, Joe has another accident here, and he's standing in the middle of a raceway or something, and he gets trampled by a horse. Could happen, right? So let's talk a little bit about what he could have done differently to give his business partners, his business interest to his partners. Probably the primary document by which business succession planning happens outside of the formation documents and the other governing documents that you create with a entity is called a buy-sell agreement. And what this buy-sell agreement essentially does is it lays out what happens when you exit the business. It doesn't have to be for accidents or deaths like Joe keeps having, but it can also be for planned retirements, if you choose to move on to another venture, something like that. Essentially, it just says, here's what happens to my interest. But since we're talking primarily about worst case scenarios here tonight, what a buy-sell agreement does when an owner dies is that typically there's two options that are laid out in a document. Either that the partner's interest reverts right back into the entity and stays there, or more commonly, the other partners are given at least the first option to purchase back that interest and allocate it per the agreement. So like I said, it's not just for unexpected deaths, also have retirements, but the important thing to remember is that eventually you're gonna leave your business, whether that's by your own will or not, if a horse catches you. But a buy-sell agreement is really kind of the simplest way that you can go about determining precisely what happens. And usually in conjunction with this, there's a formula that's used to help determine how much the person's interest is worth. It's especially important, probably applicable to most of you, in a closely held business where the stock isn't publicly traded, so there's no stock market saying this is how much this is worth. As always, it's going to be really important to consult an attorney when you draft this document because the intricacies are important in this sort of situation, and you want to make sure that you're getting everything right, especially because it's the perfect opportunity. And you're not fighting with your partners, and you're not fighting with your family, everybody's calm and rational, to make sure that you've thought through all the contingencies and you're taking the opportunity to put an agreement in writing, and everyone has the same understanding, so when something happens, you're able to go back to it. So funding this buyback of the interest is probably something you're wondering how that works, which is why typically a buy-sell agreement functions in conjunction with what's called key person insurance. Key person insurance, probably a little self-explanatory, it's insurance on your key people. And usually that's the owner, or if you have a trusted employee who's close to the business, someone you're succession planning with, you want to make sure that if they pass away unexpectedly, the loss of that person isn't going to kind of leave your business adrift. Key people, in addition to owners or other employees, basically anyone that you can look at and say, if this person leaves, is it going to completely sink my business? So that could be a family member as well, basically anybody who's involved really closely with what you're doing and knows the details of it. Determining how your business needs key person insurance is a fairly simple question. Our answer will probably always be yes. But you want to look at who your key people are and their roles in the company and how much they handle. And then deciding how much insurance to get is also a very important question. The threshold is ideally how much you can afford. You want to be able to put as much money kind of on the back burner as you can, so when something happens, worst case scenario, you've got that money that can continue your business operations or buy back the interest. Which takes me to my next point. There's a lot of flexible uses for this insurance. It's not just buying back a person's interest like we've talked about, but it also gives the company an opportunity to take some time to find a replacement for that key person or to implement other business continuation strategies, basically have a little breathing room to decide how they want to proceed. It's also a good opportunity to cover some losses that might be incurred because of the loss of that key person, whether that's by lost sales or opportunities that are missed because that person's gone, or it can be structured to cover periods of incapacity as well. So if your owner leaves, if your CEO is gone for 6 months, they can help you kind of fill that gap. And finally, always with the worst case scenario, you might be able to avoid bankruptcy or some other kind of catastrophic event, accidental dissolution, something like that, if you're able to pay off your loans or otherwise continue your business. So we're back to Joe. Joe has planned well, and he's got his LLC or corporation in place with a buy-sell agreement with his partners. And unfortunately, Joe's had another mishap, and he's contracted a flesh-eating bacteria and dies, of course. His business, because he is dead, receives a $2 million benefit from that policy, where they're both the beneficiary and the owner of the policy, so they get the payout. And the company uses that money to buy back his interest from his estate. So obviously $2 million is a lot of money, kind of a windfall for anybody. So let's talk about what happens to the cash that his estate now has. This is not strictly business planning, but this is very important for everyone, whether you have a business or don't have a business. Any attorney you talk to is probably going to recommend some estate planning, particularly if you've got assets or kids or any other family members that you want to make sure are taken care of. So there's 2 legal ways that you can die, and that's either testate or intestate. We'll talk about that vocabulary in a second here. And there's also 2 very common tools that people typically utilize in their estate planning: a last will and testament and a power of attorney. So when you die testate, that means you die with a will. You have estate planning in place, and you have taken the initiative to determine where your assets go. If you die intestate, you don't have a will, and the state statutes step in, the laws step in and say, here's where we think you would have wanted your assets to go if you'd had the opportunity to direct them. Unfortunately, like most laws that are broadly applicable, it might not be exactly how you wanted your assets to be distributed. And this chart here is a little bit complicated, but I want to draw your attention to this line here specifically, because this is my situation exactly. My husband and I don't have any estate planning in place, which is embarrassing to admit. But when we were finding out about this in one of my classes, I was horrified to find out that if I pass away and we have enough money, my husband will get the first $100,000 off the top of my estate, but then my husband and my parents split the remainder of it equally. That's not how I want things to happen. I certainly don't want my parents to inherit any assets that I might have. And I don't think my husband would probably be too happy with that either. So my goal here is to kind of scare you a little bit. It's not ideal to die intestate. For some people, it works perfectly fine. If you don't have a lot of assets, but particularly as entrepreneurs, people who are interested in building something from the ground up, hopefully with a lot of profits down the road, you're going to be in a position where you want to be able to say, this is exactly what I want to have happen. All right, so last wills and testaments are documents that you execute before you die and then become effective at your death. So basically the document says where you want your assets to go, but nothing happens until you die. So the person that you name as your personal representative doesn't have any authority until after your death, that kind of thing. In our situation here, Joe's got the opportunity to direct that money through that is received through a buy-sell agreement by virtue of his will. But wills can also be kind of a general catch-all for any other assets that are out there that may not be jointly owned or passing through other methods like a transfer on death designation or a beneficiary designation on an insurance policy or something like that. Your personal representative has powerful authority through this document because they're going to be appointed by a court, and they've got both the responsibility and the obligation to kind of collect all your assets, make an inventory, and distribute them according to your wishes. A scary statistic, because I like to scare you, is that according to the AARP, 60%, and I've seen more from other sources, of Americans don't have a will. And as almost attorneys, that terrifies us. And in fact, that's the face I made the first time I saw that. Because that means more than half of Americans don't have any control over where their assets are going. And to me, at least, that seems like the ideal situation, being able to say, I earned this, now this person gets it. So I'm going to hand it off to Abby here, right? And she's going to talk a little bit about planning for incapacity and how you can achieve that.
So we are back to our friend Joe, and Joe is the sole member of his LLC and is expanding his business into new states, which is awesome. When rescuing a kitten one day, he falls out of a tree, but he survives, but he's in a coma. So now the question is, what happens to his business now? Who gets to make decisions on his behalf? So that's where a POA is a huge benefit. So a POA is a document that allows you to appoint a person to act on your behalf as your agent, and this is only in effect for the principal, the person giving the authority for your life. Upon your death, this power is revoked. And they aren't only useful for in the situation of sudden incapacity. They're useful for if you have an aging parent, and you can act as an agent for them to conduct their business and do transactions on their behalf. Or a lot of people also use them if they're out of the country and they need to perhaps like sell a piece of property. The agent can do this on their behalf and sign on their behalf and conduct transactions on their behalf. So there are two different scopes you can have with a POA. So one is general. So a general POA just gives an agent the power to essentially make any, sign any document on your behalf. So these powers can include like handling financial and business transactions, buying life insurance, settling claims, operating business interests, which is most relevant to what we're talking about today, and making gifts and employing professional help on behalf of the principal. Also, there are two types. So the first one is durable. So a durable POA is in effect from the execution of the document until it's revoked. And this just gives the ability to somebody to transact business on your behalf. The second type is springing. So the POA goes into effect upon a certain event happening. So this would typically be incapacity, and you would need a doctor to make the determination that the principal is incapacitated and that the agent can now make decisions on their behalf. So this springing method does have a few more hoops you have to jump through, so not as many people choose to go with this method, and they choose to go with the durable power of attorney. So a huge drawback of a POA if you have a business partner, so the POA can be making decisions on behalf of the principal, and if you have a business partner, the business partner might create some tension because the agent is making decisions on behalf of the business, and they might not be familiar with this person or even like this person, so that might create some tension, so that's something you need to think about as well. But a huge benefit, so like our friend Joe, if you're a sole business owner and you're incapacitated, like Joe, someone other than Joe, it's usually a spouse, but it can be somebody else, can keep things running while Joe is incapacitated. So in the event that Joe recovers, he can decide if he wants to continue with his business or go another route, such as dissolve. So another larger topic I want to talk about today with you guys is accessing accounts after death. This is incredibly important because in a modern day society, everybody's life is essentially all online. So digital property, like real property, can be transferred to another individual through a will. Through your estate plan, so accessing accounts, and something else to think about is accessing accounts can present a lot of challenges for either your personal representative or your agent through your POA. So it's important to have the appropriate documents in place in case of an unexpected death or incapacity, so you can have a smooth transition to whoever the new leadership in your business is going to be for at least the short term, and then you can make decisions about the long term. So in the event of incapacity, this also ties into the POA I was just talking about. In your POA document, you need to be specifically granting the agent the power to access your digital accounts in the event of your incapacity. And this is usually done by citing to the Nebraska Revised Uniform Fiduciary Access to Digital Assets Act, which is a bit of a mouthful. But this is the act that gives the agent the power to access those accounts on your behalf. So in the event of your death, it's kind of a similar process. You need to grant your PR, your personal representative, the specific power to access your accounts on your behalf by citing to the same statute. So some best practices to consider is you need to assure that someone can easily access your accounts so they don't have to go through the waiting and the paperwork of talking to all these different online accounts, and that can slow down the process a lot. And if this process is slowed down, then perhaps your business is going bankrupt in the meantime or irreparably damaged because you're not filling orders and things like that. You're not providing your services like usual. So a really simple solution to this is making sure your computer is saving all your usernames and passwords, and then just locking the computer itself and giving somebody that password, a trusted individual such as your business partner or your spouse, so they can access it in the event of a death or incapacity. It would also be a really great idea to make a list of your most important accounts, so whoever's trying to piece together what's left of your business is not having to go through your browser history and trying to figure out what you were doing before your death and trying to piece together all that information. So just making a list, giving it to somebody you trust, and updating it as frequently as you can. So in most cases, 95% of cases, having the correct documents in place will allow you access to accounts, but something to consider is Google. They don't normally allow access if you have to request permission from them if you don't have the username and password, because they want everything to be kept secure. So that's something to think about as you're going through this process. So just a quick overview of kind of what we talked about today. So we talked about determining your business succession goals, and then we talked about entity formation and its benefits, and then we talked about, Cady talked about buy-sells and key person insurance and personal estate planning, and then of course I just talked about accessing your digital accounts information. So just to kind of wrap up here, I'm going to talk about some tips that you should consider with your business planning. So for your first tip, in regards to your long-term succession planning, you should start essentially from the inception of your business. Your exit strategy should be built into your business plan, because at some point, I believe Jordan mentioned this earlier, you are going to leave your business, whether it's through death, whether it's through retirement, whether it's through you just want to be able to move on to a different venture and try new things. So you should always have a plan in place. So essentially the point is, the longer you spend on succession planning, the smoother the transition is going to be. Second tip to think about is involve your family in business succession planning. Making your succession plan and then announcing it is probably the surest way to create some tension and discord in your family. Everybody wants, especially if it's a family business, everybody wants to feel like their opinions and their feelings are being acknowledged at least. So it's always a good idea to have this be a continuing conversation with your family. Tip number 3, this can be the toughest tip to follow. Look at your family realistically and plan accordingly. With your long-term succession planning, you might want your son or daughter to take over the business. but do they even have the skills to do so? Do they have the interest to do so? This can be kind of hard to accept when you've put so much time and effort into your business. So it's important that you look at your family realistically and assess who is capable of what to ensure its success, or then if you decide that nobody's capable of taking over your business, you can decide to dissolve it at your retirement. In short-term succession planning, if you have young children who are going to need somebody, or excuse me, if you have young children, it's not a realistic succession plan for your emergency succession plan. So if you die tomorrow, your 3-year-old child is not going to be able to take over your business. So it's important to be realistic about that as well. So moving on, don't be married to the idea that everyone has to have an equal share in the business. While this is a nice idea in theory, it might not be in the best interest of your business. And please remember that management and ownership are separate business succession planning issues. It may be more fair for the successors you have chosen to run the business to have a larger share of the business ownership than family members that are not active in the business. In a small business, ownership and management are usually the same thing, but as your company grows, those things might diverge. So it's important to keep that in mind. So an alternative to giving everybody equal shares is to perhaps use voting and non-voting shares so that only some of the family shareholders can make decisions on company policy. Or it might be best to transfer both management and ownership to a chosen successor and make other financial arrangements for your other children so they're taken care of upon your death. Something else to keep in mind is to train your successor and work with them. If you suddenly die and all of a sudden your son is taking over your business, but they've never worked there a day in their life, that's setting up your business to fail, and it's setting up your children to fail. So you need to, if they want to be involved in the business, you need to be telling them about your company philosophies and just practical day-to-day considerations of how things are run. And lastly, it's really important to get outside help with business succession planning. So lawyers, accountants, financial advisors, business advisors, there's so many different people that can help you create a comprehensive plan and who will facilitate the problems of both working through like family problems and both succession planning issues. So if you want to pass your family business along to the next generation, putting off business succession planning is the worst thing you can do. It needs to be a constant conversation that you're talking about from the very beginning. And then lastly, it's really important, business succession planning is not a one-time event. It's something that needs to be reevaluated at milestones in either your personal life, such as a child getting through college and perhaps they can take over the business at that point, or as your business grows, it's important to periodically reassess where your business is at and where you are personally as well. So the business you leave behind is part of your legacy, and it's in everybody's best interest to make sure it's well cared for. It's important to have an exit strategy in the event of your unexpected death or incapacitation. And then upon these events happening, don't make it any more difficult on your family members than it already is without leaving a plan in place, because that makes a stressful time even worse. So we don't want to do that to the people we love. So it's important to have a plan in place. And also please keep in mind that I think we've noted this throughout the presentation, but what we've talked about today is not just about unexpected death and incapacitation. Most of this applies to retirement as well. So it's important to plan for that, and hopefully a little bit more realistic for most of us. So it's important to keep that in mind. So that's kind of all we have for today. Thank you so much for being here. We wanted to thank SEC for providing us this space to be able to do our presentation and doing all the promoting and stuff, so we really appreciate that. And I do believe this has been recorded and will be posted on YouTube if you want to rewatch it, or if you know somebody else that would benefit from this. Thank you for your time, and if you guys have any questions, we will do our best to try and answer them for you.
Any questions?
It was a great presentation. question. I was going to ask.
Oh, yeah.
There's family and friends of mine who I know should be in this room tonight but couldn't make it or have no idea, and I just wanted to share that, a link or something with them, so.
I believe, yeah, Steve will be able to direct you. Did you say the SEC has their own YouTube channel?
Yes, we have our own YouTube channel. The video will be available probably sometimes tomorrow. And we'll promote the availability of that video. And then also, I think on the sign-up sheet, you could indicate whether you wanted a copy of the slides. And I think you guys will take care of that. But if any of you are out there in the learning centers, in Hebron and Fall City and Nebraska City and Plattsmouth, if you want a copy of those slides, give your email address to the local learning center manager, and we'll make sure you get a copy of the slides as well.
I have a question. Yeah. So in an escort situation, I want to make sure my husband can get to my bank accounts.
Sure.
And so I was going to get him through the Secretary of State, add him to my business. Is that the best way, or is it more through the power of attorney?
Yeah.
Sort of thing, or is it maybe that's a little bit of both?
It is, and part of what's important about doing all this planning is that it's, I'm sorry. She's wondering, essentially in her business, and you said you have an S corp currently, okay, so she has a, and for those of you who don't know what that is, it's a corporation with a slightly different tax structure, so there's a little bit more information on the handout there, but she's asking how her husband can have access to her bank accounts. And is that business bank accounts specifically?
Yeah. So
probably is the answer. Making sure that you've got that, your bylaws in place. If you're adding him to his business, adding him to your business, making sure that everything is delineated, that he's a co-owner essentially. But in my experience, a lot of financial institutions don't maybe have a level of sophistication to look at a document of that length and say, yep, here's the exact provision that will allow this person. So
okay. That's another question.
Yeah, so you're probably going to want to go to whoever your bank is and say, I'm interested in doing this, and whether it be a joint owner or an authorized signer on the account or something like that. It's important to just be kind of consistent across all of your planning, and like Abby was talking about, looping in all of your advisors at every stage. So accountants and lawyers are an easy one to think of, but it's your financial advisors and your investment advisors, and basically everyone who might touch the business in any way should be involved. Any other questions?
Yeah. 1 or 2 or 6.
We're here all night. Keep going.
In a corporation type S or LLC or whatever, you were saying that that's going to protect your personal assets. How does that, how so? Because if you're going to get sued as a corporation, they're also going to sue you personally, right? If they're smart, they would, right?
Yeah.
So they would name both. And then the other question is, how do you get financing as a corporation without doing a personal guarantee?
All good questions.
I guess,
do you guys want to?
I guess with the corporation, you could have contractual liability or tort liability. So if you're going to be held personally liable, that's usually going to be a tort liability. Like someone slips and falls in my business and gets injured, that's a tort liability. They wouldn't be able to sue you individually.
No, you'd have liability insurance for accident, injury, that sort of thing. I'm talking about
contractual liability.
You build, let's say I'm in construction, you build a house or something and one of the walls falls off or something after people live in the house for a year or 2. And they want to sue you and the corporation.
So there's a level of, it depends on what the lawsuit looks like, it depends on what happened factually that comes into play there. It depends is the favorite lawyer go-to. It's always hard to give a straight answer about that.
That being a corporation protects personal liabilities, but in fact it really doesn't.
Well, were you in the, if you personally were on the job and that the liability sprung from your work as an employee of the company, they wouldn't be able to hold you personally liable for that.
So if you're doing business
I
within
think
them.
if you, as an owner, if you actually work on a project, and personally complete an aspect
I
like
see.
painting or trimming or whatever, you are then liable. Whereas if I would hire someone to do painting
I
or
see what you
trimming
mean.
or whatever, I'm not liable.
There's a special set of regulations for the construction industry, as I'm sure you're aware. And unfortunately, I'm not prepared to talk in too much depth about those tonight. What we're talking about when we say that the entity structure is going to limit your personal liability is essentially just, and I'm not saying that you've got it wrong at all, but outside of perhaps your exact example, the corporate formalities, the different things that you have to do to keep your entity in good standing on both the state level with the Secretary of State and kind of the internal things about keeping all your records. If you're doing everything correctly, that should offer that shield. And if you're being sued as either the business owner or the partner, or whatever it may be, if you've got some sort of ownership of that entity, that's kind of the whole point, is that ideally that offers that shield. And that if somebody is suing you personally, on top of that, maybe there's some fancy footwork your attorneys can do to say that the personal liability part of that suit actually isn't applicable because you were doing business through your entity. And so your entity protection comes into play there, and that part of the suit can be kind of separated and thrown out, if that makes sense. But of course, if you're being sued, they always want the deepest pockets, so the attorneys on both sides are going to make the best
Why
arguments.
wouldn't somebody would sue you? Why wouldn't they sue as many people as they could at the same time?
Yeah. I think that's generally what they do. They see what sticks.
Was there a second part of your question that we didn't answer?
Financing.
Financing.
Yeah, the personal
Yeah.
guarantee on the, who gets credit without personal guarantees?
Yeah, it's a very fair question. And
If you're a new business, I think you're going to have to personally guarantee a loan if you don't have any track record. But once you have kind of established yourself and you have some income, then you are not as likely to have to
Consider an
personally.
established business.
I'm sorry, what?
What would you consider an established business? How many years?
I mean it really depends. That depends on what the person giving you the loan thinks is an established
If you're a
business.
owner of a bank, I can tell you that
Yeah.
as a new business, yes, you'll have to give personal guarantee, and then after your business has been up and running, maybe 5 or 6 years, and you can show that you've been profitable.
Essentially, once
they
you
may
have
extend
assets.
Credit to just the business.
And of course, if you've got assets within that entity that are sufficient to cover the money you're asking for, that's probably going to be.
What kind of creditor would do that?
If your assets are more than your liabilities on your balance sheet. you can get
What kind of a creditor would guarantee, financing, without personal guarantee?
Sure, I think most banks would probably be willing to discuss that with you, particularly at a small business level. In my experience with banks locally, and I don't have a business, I haven't been looking for personal funding for a business, but from what I know kind of from talking to my colleagues and everything, is that a lot of businesses, especially in our community, would probably be willing to, if you've got the money to cover the money they're lending to you, within your business, it might be sufficient for them to not ask for personal guarantee.
I'll also chime in too. I think it depends on what the loan is being used for as well.
Yeah.
So if you're taking out a loan to pay employees, that's not an asset. The money goes in and out the door as soon as you get it. If you're, borrowing $1 million for equipment that can be resold for $900,000, that's a very different equation. They'll put a lien on the property, and they may decide that's more of a risk they take earlier on because they get most of their money back. So definitely a conversation. You might get different answers from different bankers as well.
Does that more or less answer your questions?
Well,
Insufficiently in part,
yeah.
I know. Anybody else? And we didn't talk about entity structures in too much depth tonight because Steve had told us you've seen some presentations on that topic, but we're happy to discuss some more in-depth questions if you have any, of course. Yes, Brett.
So my question is, when I figure out my awesome small business or startup, and if I want to take some of these action steps, how can the Weibling Entrepreneurship Clinic help me?
So you can fill out a client intake form. I will warn you, we do have a bit of a wait list right now, but you just need to fill out your information, kind of where you are in the process of starting your business, if you formed an entity yet, if you have not, and then we can do a client intake interview with you if you're chosen as a client, and then your student attorneys can kind of go from there deciding how best they can serve you.
And part of the benefit that the clinic offers is that if you think an LLC is the right form for you at this stage in your business and your goals, we do have a DIY packet. It essentially gives you a form with that initial filing that you have to make with the Secretary of State that will set you up, and some more instructions about what you need to do to keep it in good standing and how you should proceed with it. So please let us know if there's anything else we can help you with. All right, well, if there's no more questions, and it looks like we've lost most of the people, we appreciate you coming here tonight, and hope you all have a good evening.
Thank you.
All right.